Should you tell your attorney the truth, even if it is really bad? That is a question that I'm going to be answering in this video. My name is Veronica. I'm an attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. I'm also the creator of a course on how to represent yourself at your restraining order hearing and win. So if that's something you're interested in, make sure you get your free first class via the link in the description box down below. Okay, so let's jump right in. A lot of people are hesitant to tell their attorneys the truth, especially when it's bad. And actually, some attorneys will flat out tell their clients not just to not lie, but to literally not tell them their side of the story. And the reason for that advice from attorneys is because an attorney cannot present evidence that they know is a lie. So I can't knowingly present text messages that I know are doctored, or put my client on the stand and ask him questions to allow him to tell a story and help him tell a story that I know is false. To me, as an attorney who practices solely in litigation, I need to see the truth so I can protect you. If I ask you to tell me what happened and you tell me a story that is a complete lie, then that could seriously screw up our case. We could lose our case because of that. Most people are not brilliant liars who are covering every possible angle. And even if they are, I've had some extremely smart, well-educated clients, I will say smarter than me, but they might not know the nuances of the law well enough to lie so well that they win their case because of the lie. Let's say maybe you knew the law too. Maybe you are a trial attorney, right? Maybe you're a really good liar, really smart person. You know the law. What you're missing then is a third-party perspective. One thing that I always do with my clients is I want to go through their story and I want to ask them the hard questions. The first time that they are asked a hard question should not be when a non-friendly attorney has them on the record and they are under oath. I need to ask them those questions and point out problems with their answers, especially if we are in a situation where they're going to have to give a statement or where they want to give one. I know some of you watching still don't believe me. You might think that you are the exception. So let's go through some examples of how this can really backfire in ways that you may not be expecting. Example number one, let's say that you are facing criminal charges for misdemeanor domestic battery, and you tell me as your lawyer that you have no criminal history, right? And I get your rap sheet, which comes with discovery, and it's clean. All right, and let's say the prosecutor has offered you probation, and I've done everything I can to try to shake them down, but for whatever reason, they don't want to go below probation. They don't want to offer you classes in exchange for a dismissal. And let's say I've been in front of our judge before, and I know that if we go to trial and we lose, the worst that you will get from that judge is almost certainly going to just be probation, the same thing that you're being offered. So I explain that to you, and you agree, okay, we might as well roll the dice. We might as well go to trial because worst that we'll get is basically what you're already being offered. But just before trial, the prosecution uncovers that actually you have an old domestic violence conviction from another state, one that you didn't tell me about, and you were hoping that nobody would find out about. Maybe you thought when I got that initial rap sheet that if it wasn't on there, then it was never going to come out. And once the prosecution discovers that out-of-state conviction for domestic violence, you now face harsher penalties. The jury is going to very likely hear about that prior domestic violence case, which obviously looks terrible for you. And at that point, the DA says that the deal was rejected and you cannot go back and take it now, even if you want to. Now, if you had told me the truth that you do have this out-of-state conviction, and I look at the rap sheet and it's not on there, then I would probably verify to make sure that you really did have this out-of-state conviction. Some people think that they've had a conviction just when they were arrested, so I would want to verify that. But if it was true, then I would probably tell you to take that deal and run before the prosecution finds out and you are facing a much more serious case. Look, your attorney is on your side. We do want the best outcome for you, and our advice, it's only as good as the information that it is based on. Example number two, you're in a car accident, you come to me, you tell me that you were in this bad car accident and it was caused by the other driver running a red light and you have been injured, you want compensation. So I file a lawsuit against the other driver, but the other driver's insurance company gets video from a gas station nearby, which clearly shows that actually you ran the red light. Not only is our case going to be dropped, but in a situation like that, if the other driver was initially not planning to sue you, they might become angry enough that you've put them through all this and that you have falsely accused them that they file a lawsuit against you. All of that could have been avoided if you had told me the truth from the very beginning. And actually, even if one person runs a red light, it is possible for the other person to still be at least partially at fault and potentially get compensation there. And that is information that your attorney has. So we just need the truth from you so we can combine those and assess your case properly for you. Example 3, and this is actually from a trial that it was not my client, but I watched this trial and I saw some of this happen. Your ex-husband accused you of domestic violence and got you arrested. So you come to me as your attorney and you tell me that he completely made it up to get custody of the kids and get you to pay alimony. You explain that he did get minor injuries on the night that he got you arrested, but only because he was drunk and he tripped over his own feet. So the case gets all the way to trial. You take the stand and you testify as you told me, your lawyer. You testify that there was no argument and nothing happened at all that night other than him drinking too much and falling down. However, unbeknownst to you, the prosecutor has ring video from a neighbor that captures audio of the two of you in a screaming match that night. Now, you may think, or that defendant whose trial I watched may have thought that the prosecution would have to turn over every bit of evidence that is at all related. There are some exceptions to that. One of them, which could arguably apply here, in which the judge in that case did say applied, is for impeachment, where the prosecutor is not planning to use that evidence against you, and it's not evidence in your favor. The prosecution is just not planning to use it unless you get on the stand and claim that there was no argument. You say something that is directly contradicted by the evidence that the prosecutor had, which you as the defendant did if you said that there was no argument, he's just getting drunk, tripping and falling, and then there is video with audio of a screaming match. Now, in reality, and the tragic thing about this trial is it seems that the truth was that there was an argument, there was yelling, but the defendant potentially had a self-defense claim. The thing is that even if you injure the other party, if you did it because the other party attacked you or you believed that the other party was going to attack you and that belief was reasonable, you have an argument for self-defense. But once you get on the stand and lie, especially as the defendant in a criminal case, you are pretty much done. Example 4, and this is also closely inspired by something I saw in real life, thankfully not my case, but you are involved in a car accident and you are injured. When meeting with me, your lawyer, you give me photographs of your injuries, which I give to the other side with your permission and as is required in a civil case. During the case, the other side's attorney looks at the photographs and thinks that something might be off. So that attorney submits the photographs to a forensic expert who determines that you had used a filter to enhance the photos and make your injuries look worse. Ultimately, your credibility and our case is completely destroyed. The tragedy there is that typically your damages from an injury are more likely to be based on your medical records, not how severe the injuries look. Just by putting a filter on a bruise or an abrasion, as was in this case, and making it look a little more red, a little more purple, it's really not going to make a big difference in the case, except for when you get caught. And these are just a few examples, and you may be thinking, you know what, I wouldn't make a lie that severe. But the thing is that you really should tell your attorney the truth unless they specifically tell you not to. There may be consequences that you have no idea could apply to you and your case, and that your attorney will not know to warn you about. It could really blow up in your face in ways that you may not even realize are possible. I hope you found this video helpful. If you do have a case in California, my firm does practice criminal defense and personal injury. You can find my number down below. You can also book a consultation there. And if you did find this video helpful, please don't forget to like, subscribe, ring the bell, and follow me on Instagram, TikTok, and Facebook.